Antes de iniciar con el cuarto panel de discusión, escucharemos las palabras del señor Fitzgerald Haley, embajador de los Estados Unidos en Costa Rica.
All right. Where is Evelyn? Good afternoon, distinguished speakers and guests, ladies and gentlemen. I am honored and grateful to be able to join you today. I wish I could say we are here to celebrate our success, that we've made significant progress toward protecting our journalists and independent media. Of course, we all know that that is decidedly not the case. We are here because reporters around the world are under threat. They are being attacked and they're being killed. As President Obama said earlier this year on World Press Freedom Day, the free press is far too often targeted by governments that want to avoid the truth and leaders who mistrust the ability of their citizens to make their own decisions. And when our journalists are threatened, when our ability to investigate and report the news is attacked, then we as a global community are not progressing. We are getting worse, not better. We are not making our own decisions. We have fewer rights, less democracy, and less freedom. And so all of us have a responsibility to defend real journalism and protect our frontline reporters. I am particularly pleased that Costa Rica is hosting this discussion. Costa Rica's long-held traditions of protecting human rights and freedom of expression are a model for the region, and I hope they will continue to provide desperately needed examples, expertise, and leadership. Nevertheless, we can never take the freedom of press for granted. The reality is that the press holds a great power and can easily become the target of ill-intentioned actors. Even in countries with strong democratic traditions, powerful individuals still may act to silence journalists who dare say something they don't agree with or expose something they wish to keep hidden or publicly misleading. Likewise, attempting to curtail press freedom through government intervention under the false flag of fostering democracy is an absolute antithesis to democracy. We must always be vigilant to the threat posed against the press in every nation. A threat against a journalist is a threat against us all. And sadly, we don't need to look too far afield to see tragic examples of reporters under attack. In Mexico, organized crime figures have targeted innocent journalists for doing their job. In Venezuela, the government's arbitrary detention and excessive use of force against protesters and journalists, and its drive to shut down foreign media and internet, clearly endanger human rights. These threats are real, ongoing, and require constant vigilance on the part of media professionals, government and civil society bodies, and everyday citizens. For that very reason, it is reassuring for me to see so many experienced and passionate experts and practitioners from around the world together today to examine how we protect journalists and fight the climate of impunity that protects their assailants. I am pleased our embassy was able to support the travel of several of the conference's keynote speakers, including representatives from the Organization of American States and the Center for Law and Democracy. Together, they have decades of experience as journalists, lawyers, and human rights experts. I trust that their thoughts and insights have helped to frame the dialogue at this conference. With so many extraordinary minds together in one place, I am sure we will all walk away wiser and more equipped to face the threats to journalist and press freedom that are all too common in every region of the world. To journalists worldwide, we stand with you. Thank you very much.
Good afternoon, everyone. Please.
Antes de iniciar con el cuarto panel de discusión, escucharemos las palabras de la señora Pilar Álvarez, de la UNESCO.
Es brevísimo. Embajador, muchas gracias por haber acudido a este evento organizado por UNESCO, en el que, por supuesto, contamos con la compañía y con el apoyo de los 195 países miembros de UNESCO para continuar con este trabajo. A todos ustedes contarles que estamos en una magnífica casa, en un magnífico recinto y sumamente solemne. Su solemnidad nos ha llegado y hemos hecho un evento en el que hemos estado presentando lo que cada quien ha querido, por supuesto, compartir y reflexionar con nosotros. Queremos decirles que estas ponencias van a estar disponibles. Por lo tanto, será ahora, quedará por cuenta de los moderadores, si quieren seguirnos presentando las ponencias, que ustedes sepan, que tengan la tranquilidad que el trabajo realizado y el esfuerzo que han hecho por poner sus ideas en papel van a ser difundidas, pero aprovechar que tenemos aquí un foro vivo, palpitante, respirando, que quiere sobre todo y puede ofrecernos debates con gran riqueza que podemos entonces aprovechar de otra forma el resto del seminario que tenemos o de la conferencia internacional que hemos organizado. Contamos con ustedes entonces para saber que pueden salirse un poco del cartabón de solamente la presentación por escrito y la presentación leída o la presentación oral presentada y poder proceder incluso preguntas y debates y con ello generar discusión si es que esto es posible. Muchas gracias.
De esta forma iniciamos el cuarto panel de discusión titulado Jurisprudencia, Organismos de Protección de Derechos Humanos Universales y Regionales, para lo cual cedo la palabra al señor William Horsley, representante del Centro de Libertad de los Medios de la Universidad de Sheffield.
At last. Good afternoon, everybody. I hope it's not too much of a shock that I'm speaking in English. This is a fairly international panel. I think we have at least 3 speakers who will speak in English here, and we will make it definitely more interactive. So please prepare to join a real conversation. I should introduce myself. I should say, first of all, an enormous thank you to the organizers of the conference, really to the Inter-American Court of Human Rights, to UNESCO and the OAS. I'm William Horsley from the Center for Freedom of the Media at the University of Sheffield, and I do feel a sense of co-ownership of this because our center, together with UNESCO and the Council of Europe and the European Lawyers Union, helped to organize the event just a year ago to mark the very first International Day to end impunity for crimes against journalists. So many thanks for this opportunity. And it is a great shame that we are not able to have a representative from the European Court of Human Rights here today because we've had such brilliant and stimulating discussion already about the case law from different parts of the world. And what we want to focus on in this panel, I'm going to suggest, is how the different branches of the global protection system for journalists against violence and particularly impunity may work together more effectively, very much in the spirit of what was said at the Strasbourg meeting a year ago and in the spirit of what UNESCO has told us about this meeting, which is that they hope this will be repeated. And I want to suggest that this meeting can help not only to put the bricks up of such a system for strengthening and extending the framework, but to put the mortar, to put the cement in between it so that, it has a real effect on the numbers of attacks and in particular in diminishing the rate of impunity. So we have a dialogue with a purpose, and to help us to do that, we'll be hearing first from Judge Agostino Ramadani, who's the president of the African Court of Human and People's Rights. He's just arrived. Thank you for being here. Andris Melakals from Latvia, who's a former president of the Council of Europe's Steering Committee on Media and the Information Society. Victor Emmanuel Rodriguez Recha, who's from Costa Rica and a member of the UN Human Rights Committee. And Roberto Caldas, who is one of our hosts from the Inter-American Court of Human Rights. To stimulate the debate, having heard what was said this morning, I would like to put 3 or 4 points before the panel and yourselves. The panel will be invited to make their own remarks, but perhaps some of these points may be addressed. The first is we've been talking a lot about case law, particularly in the inter-American system, but also how that can be cross-fertilized with the case law from elsewhere, and indeed the experience of the human rights of the UN human rights treaty bodies, and so on. In Strasbourg, there was a lot of discussion about how this cross-fertilization could be made more full and productive. For example, the European system has what might be described as a weakness when it comes to the court ordering protection in cases of imminent threats against journalists. In the European Convention system, it is called Rule 39 of the Court, and there was considerable discussion in Strasbourg a year ago about whether lessons might be learned from the experience of the Inter-American Court in that area, and vice versa. It was also suggested that it might be productive, and the Council of Europe was fairly positive about this idea, to consider some kind of a codification or compendium of international norms and standards, which in some way might set a standard for all regions to try to reach. Secondly, how may the UN system itself be strengthened? How may, for example, the work of the Human Rights Committee, General Comment 34 on freedom of expression in particular, may be applied across borders in a more proactive way? We heard from Michael O'Flaherty, who was, I think, the main author of that General Comment 34, saying that the existing system of treaty bodies may be used more vigorously and is directly applicable. Luckily, we have Mr. Rodriguez-Recha here, who will be able to comment on that. Then there is the question of to what extent some cross-cutting or imaginative work done by different regional bodies and UN bodies might help help to assist those regions of the world which have not got such a developed system. In Strasbourg, we had a representative of the African Lawyers Association. We were not able to have someone from the African Court. We had a lawyer from the Philippines who spoke about the extremely high rates of threat and impunity there. Philippines, of course, is the site of the worst single killing of journalists in history, the 32 journalists killed in the massacre at Maguindanao in 2009. I'm hoping that Judge Ramadani will have some thoughts on the way in which Africa might benefit from that cross-fertilization. And finally is the question of the responsibility and role of individual member states. We have Andres Melacals here, who is an experienced member and former chairman of the Council of Europe's Media and Information Society Steering Committee. And what we have recently heard from the Secretary General of the Council of Europe is that there has been a backsliding. There is a very serious backsliding in the maintenance of the rule of law, and particularly the freedom of expression and safety of journalists in the European area. And we hear from my country, the United Kingdom, that government ministers are speaking openly about the need to curtail the powers of the European Court of Human Rights, to cut the link with Strasbourg and rely more on national laws and so on. This is one example of a trend which is rather widespread in many parts of Europe, if not in this area. And one final question I have for people is, what about the role of the concept in law of positive obligations? Because this is now the focus of new texts and new expectations in the European area, which are being elaborated in a committee of which I am a member, which will deliver a new text, a so-called recommendation by the Committee of Ministers, we hope, early in next year. And the idea is that the concept of positive obligations is something which all member states of the Council of Europe should see is upheld through a regular and a comprehensive review of all their laws and practices which may affect freedom of expression. So that's quite a heavy menu, but luckily we have brilliant speakers, and I promise you we will have also a chance for open conversation. So Judge Ramadani, I'll ask you to speak for 10 or 12 minutes first, if that's all right. Thank you.
Thank you, moderator. Good afternoon, colleagues. All protocols observed. I'm coming from the African Court of Human and People's Rights. It's a rather young court. So with the permission of the moderator, I've asked him if I could briefly introduce this court. I'm sure most of you don't know anything about this court. It's relatively a new one. Now, there is what we call the African Charter of Human and People's Rights. This was adopted in 1981. Now, that charter created the African Commission of Human and People's Rights with two mandates: one, to promote, and two, to protect human rights in Africa. Unfortunately, the decisions of that commission is just where they just made a recommendation. They were not binding. So the heads of states decided that they should create or adopt a protocol to that charter, which created the court to which I'm now presiding. So that that protocol was adopted in 1998. It came into force in 2004, and it started operations 2006. So 2006 to date is not even 10 years. It's just about 9 years. Actually, it started in November, so it is not even 9 years. It's some 8 years and some months. So that's why I'm saying it is a relatively younger court, which I need to introduce. That court contains 11 judges who are elected for 6 years, but can be re-elected for another 6 years. And the judges are not full-time, apart from the president. Others just come 4 times a year for about 2 or 3 weeks, and then they go home. We are going to meet for our last session for this year in November. And then after that, we wait until next year for our first session. Now, in order for that our court to be operative or functional, we need ratification. That protocol has to be ratified by the 54 member states of the African Union. And also, now, until the moment, it's only 29 African states have ratified that protocol out of 54. It's really appalling. And our main job is really going around to sensitize that. I was just in Johannesburg. I left just yesterday at about 7:30 in the evening, and I had these 16 hours from Johannesburg to Atlanta, then 4 hours Atlanta to here, and now to be addressing your excellencies. If you find me staggering, it's because of that the jet lag and the being tired. Now, we go around trying to sensitize African countries to ratify that protocol. But there is also another requirement that an individual state has to make a declaration which would allow their individuals and NGOs to come directly to our court. Now, out of the 29 states which have ratified the protocol, only 7 have made that declaration. So we get cases directly from individuals or NGOs from only 7 African states. And that is our main concern. South Africa, for instance, has ratified the protocol, but has not made the declaration. And this was my mission yesterday from 9 until I think about 4, talking to lawyers, saying, please, 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 convince President Zuma and the rest to make the declaration. Now, our jurisdiction is most contentious, and also we give advisory opinion. And because of the declaration, Some, we have direct access to the court or indirect. Direct access is when a country has made the declaration, so their citizens and NGOs can come to us directly. Indirectly is where a country has not made the declaration. So an individual or NGOs can go to the commission, which is in Banjul, Gambia, and then the commission can come to us, can bring that matter to us. So the matter will come to us indirectly that way. I don't want to go further into that. Now, states have undertaken to be bound by our judgments. Hence, our judgments are final and binding. Until recently, when I was in Joburg just yesterday, I was with my registrar there, and I'm told that we have 53 cases. Otherwise, we had 50, but up to yesterday, we have 53 cases all over since the court started. And we have disposed of 24 cases, and 29 cases are still pending. Now, what is the law applicable? The law applicable is the Charter of African Charter on Human and People's Rights, but also any other human rights instrument to which parties which are before us in court are signatories. So we can use international instruments and what have you. Now, as for the execution of our judgments, when we give our judgments, we send the copies of our judgments to the parties concerned. And also we send copies of that judgment to all the African states. And then also to the member states, to the members of the Executive Council. Now, the Executive Council is a council containing foreign ministers of all the African states. And they have the job of having to supervise the execution of our judgments on behalf of the Assembly. The Assembly now is a meeting of the heads of states. So much, I think, for that. Now, let me go straight to the topic, because I think I was given some 12 minutes. I don't know whether I've taken some 2 minutes out of my 10. Now, as I said, the law applicable is all instruments. So with the question of immunity and guarantees of freedom of expression, we use Article 19 of the Universal Declaration of Human Rights. We also use Article 9 of the African Charter on Human and People's Rights. And then we have the African Charter on Democracy, Elections and Governance. And there we use Article 2, Sub-Article 10, and Article 17, Sub-Article 3. But there is also another organization economic organization of West African states, or in short they call it ECOWAS. They have their treaty, and we use Article 66 of that treaty. But we have in East Africa, the East African Community, and it has got a treaty there, and we use Article 6, paragraph G, dealing with the protection of journalists. And then we have also the SADC countries. They've got a protocol on culture, information, and sports, and we do that. Now, we have had only 2 cases on our court with respect to journalists, and both of those cases have come from Burkina Faso. Burkina Faso was the first country to ratify the protocol setting up the court, and also was the first country to make a declaration allowing the individuals to come to the court directly. Now, the first case is what we call is the case of beneficiaries of the late Norbert Zongo, Abdoulaye Nikiema, alias Ablase, and Ernest Zongo and Blaise Ilbodu, and also the Burkinabe Human and People's Rights Movement against the Burkina Faso state. Here, Norbert Zongo was an investigating journalist and the director of a weekly magazine, Le Independent. he investigated the death of one David, who was the chauffeur of Francois Campore. And Francois Campore is the brother of the president of Burkina Faso, and he was also the advisor to the government of Burkina Faso. Now, he made his investigations of the death of that chauffeur of that brother of the head of state of Burkina Faso. And as a result of that, he and some 4 of his colleagues just disappeared. They were murdered. Now, the beneficiaries of these slain journalists came to us complaining 2 things. One, that the Burkinabe authorities never bothered to investigate the death of these journalists and so as to bring them to book. And them, the beneficiaries, tried to do the investigation so as to bring those murderers to book, but they were somehow stopped or deterred by the Burkinabe officials. So when we came to hear that, we saw that, yes, these people were murdered, and the Burkinabe government has done absolutely nothing to bring the perpetrators to book. 3 minutes, okay. I can do business with that. So what happened is that we ordered some compensation or reparations to the spouses of the enslaved people, their children, and their parents, and also some reparations to their advocates who came all the way to Arusha, Tanzania, where we have our headquarters. And then we made an order that the Burkinabe government to publish the summary of our decision in some of the official gazettes, as well as journals, popular journals. And we have ordered the Burkinabe to reopen the investigation so as to bring these perpetrators to book. Then another case from, again, Burkina Faso is Lohe Issa Konate. Now, Lohe Issa Konate did some, what in common law system, they call it criminal defamation. And he was charged, he was imprisoned for 1 year, and he was also fined heavily. And he came to us saying that we should order the decriminalization of criminal defamation. Now, we said, we hold that no, criminal defamation can stay there, but the punishment should not be imprisonment, but by paying fines. And we also ordered compensation. Thank you.
Thank you very much indeed, Judge Ramadani, especially for keeping to time and giving us an introduction to the African system. I'm torn, really, whether we should allow people from the floor to join the conversation early. But since we are in full flow, if you agree, I will continue now and ask Andris Melekals to speak from the European perspective. Andris is from the Ministry of Culture in Riga. He's a former member of the National Broadcasting Council, and most importantly, he sits on the intergovernmental committees of the Council of Europe. Bearing in mind the structure of the Council of Europe is that the execution of judgments is the responsibility of the Committee of Ministers to follow up, although there is a provision for it to be sent back to the court. Essentially, it is a political backing of the Council of Europe that makes the system work. And of course, the Committee of Ministers, as the intergovernmental directorate, produces a large number of pieces of advice, including an important one, guidelines on eradicating impunity for serious human rights abuses. Not only journalists, but all human rights abuses several years ago. Many of these, it is alleged, do not have the desired effect. And it is on that note that I turn to Andris to ask him his view about the strategy of the Council of Europe for implementing the standards which are set out in the Convention.
Thank you, William. It's a great pleasure to be here, and coming from Latvia, I feel duty-bound to mention that in May this year, we had the privilege of actually hosting World Press Freedom Day conference in our capital city, Riga. I'm very grateful for this chance to address you on behalf of the Council of Europe Steering Committee. Its abbreviation is CDMSI, so I don't have to repeat the whole title of it. I'll paint a very different picture than you've... No, I'll start by saying, if anyone is still under the illusion that all is well in Europe as far as the safety of journalists is concerned, then forgive me if I disappoint you. As William mentioned at the beginning, the Secretary General of the Council of Europe, Thorbjørn Jagland, in his 2015 report on the state of democracy, human rights and the rule of law in Europe, it does actually make for grim reading. For example, the safety of journalists from violence and threats, an enabling legal environment for their work and access to information held by public authorities are not satisfactorily guaranteed in almost half of member states. Even where the situation is satisfactory, a significant number are regressing, and over a third of states are experiencing a deterioration in protection for journalists. Among the member states with an unsatisfactory rating, the negative trend is primarily due to violence against journalists, lax or non-existent prosecution of perpetrators, and widespread politically motivated imprisonments. Now, where have we heard this before? Only on a few days ago, on the 1st of October, Secretary Jagland released the following statement. I strongly condemn the brutal attack yesterday night on Hurriyet journalist Ahmet Hakan, who has been under threat for some time. The repeated attacks on journalists in Turkey have a chilling effect on freedom of expression in the country. I call on the Turkish authorities to fully investigate this attack and bring the instigators and perpetrators to justice. Let me now give you just a brief update on what we're doing at the Council of Europe. The CDMSI, the committee on which I sit, it's a standard-setting body composed of representatives from all member states and observers from other interested countries, international organizations such as UNESCO, the OSCE and the EU, as well as leading European organizations representing broadcasting, print and internet media. The interests of journalists are very actively represented by the Association of European Journalists, of which William, our moderator, is a representative, and the European Federation of Journalists, which is a part of the International Federation of Journalists. Working groups can be set up to work on specific issues, and one of these is the Committee of Experts on the Protection of Journalism and Safety of Journalists. It's chaired by Françoise Tulkens, former Vice President of the European Court. The standards set by the CDMSI, my committee, in the form of recommendations and guidelines are popularly known as soft law. That is, they are not legally binding on member states, but are referred to by both national courts and the European Court of Human Rights. In turn, these recommendations usually envisage the need to observe the provisions of the European Convention on Human Rights and indeed the case law of the ECHR. Back in 1994, at the Fourth European Ministerial Conference on Mass Media Policy, ministers adopted not only a resolution on journalistic freedoms and human rights, but also a statement on violations of journalistic freedoms, in which ministers, now this is in 1994, were appalled by the fact that the number of disappearances and deaths of journalists has been greater in Europe within the last 36 months than anywhere else in the world. Just over a year later, the Committee of Ministers adopted its first instrument dealing with specifically the safety of journalists. This was recommendation number 4 of 1996, on the protection of journalists in situations of conflict and tension. The appendix to the recommendations set out 12 basic principles concerning the protection of journalists, ranging from their physical safety, access, confidentiality of sources, and insurance, to the duty of states to investigate attacks on journalists. If we jump forward now to 2011, the Committee of Ministers adopted guidelines on eradicating impunity for serious human rights violations, in which it was stressed once again that impunity must be fought as a matter of justice for the victims, as a deterrent to prevent new violations, and to uphold the rule of law and public trust in the justice system. 20 years after the Prague conference, we cannot say the situation has greatly improved. In April last year, 2014, the Committee of Ministers adopted a declaration on the protection of journalism and safety of journalists and other media actors, in which, once again, we can read, journalists and other media actors in Europe are increasingly being harassed, intimidated, deprived of their liberty, physically attacked and even killed because of their investigative work, opinions or reporting. These abuses and crimes are often met with insufficient efforts by relevant state authorities to bring the perpetrators to justice, which leads to a culture of impunity. This declaration invited member states, among other things, to review at least once every 2 years the conformity of domestic laws and practices with their positive obligations to protect journalists and other media actors. I've now been given uno minuto, so I will jump very, very quickly to a problem that we have, and which was raised also in the discussion this morning. It's the issue about how do you define journalism and what is a journalist? One of our member states, I'll call it by name, Russia, has entered several reservations to recommendations based on the fact that Russia does not recognize expansion of the notion of the word journalist to include bloggers, whistleblowers, human rights defenders, or other persons performing journalistic activities or public watchdog functions. Now, the irony here is that if you are a blogger in Russia with over 3,000 visits a day, then you have to register as media. So this is frustrating for us at the Council of Europe. 46 member states say, yes, we have to expand the notion of journalist, and one says no. Thank you, William.
Thank you very much, Andres. I'd just like to underline something that Andres said towards the end there. The idea, this is a new concept, I think, that governments would agree among themselves that they have a voluntary duty to review their own laws on sensitive areas, national security, terrorism, extremism, in order to bring these into line with the norms and standards of the Convention on International Law. This is an idea I know that Michael O'Flaherty, your former colleague on the Human Rights Committee, advanced in the OSCE several years ago, and it will be worth watching closely to see whether in some countries this happens, because the idea of a judicial review of laws which are open to abuse or which are simply in themselves contrary to commitments, I think is a valuable one to add to the arsenal. On the European front, well, let's continue the conversation, and I'll pass the baton straight away to Victor Manuel Rodriguez-Recia from the UN Human Rights Committee to elaborate on your perspective and what you've heard today. Thank you.
Gracias, señor moderador. Es un gusto estar en la Corte Interamericana de Derechos Humanos, hablando de un tema de un derecho síntesis que involucra de alguna u otra manera la protección de otros derechos que lo integran, como el acceso a la información, que es una dimensión de la libertad de expresión, también del derecho a la manifestación y el derecho a la reunión. Yo me voy a referir a este tema empezando por la parte final del que me precedió sobre la gran pregunta de si el ejercicio del periodismo va a involucrar únicamente a profesionales que ejercen el periodismo o si también puede involucrar a otras personas que no necesariamente son periodistas, pero que también ejercen el periodismo de alguna u otra manera y en relación con esa función, su vida, su integridad y sus otros derechos humanos pueden estar en riesgo. Estamos en el recinto de la Corte Interamericana que fue valiente y visionaria en la opinión consultiva OC5 en relación con una pregunta que le hizo Costa Rica sobre si la colegiatura obligatoria, porque en Costa Rica estaba reglamentada la colegiatura obligatoria, violaba o no la Convención Americana. La Corte Interamericana dijo que sí se violaba la Convención, es decir, la colegiatura obligatoria, y eso vino a abrir el debate, de tal manera que en el caso de Costa Rica, aunque no era un caso contra Costa Rica, sí involucraba el ejercicio abierto y libre de la libertad de expresión. A partir de ahí en Costa Rica se puede ejercer el periodismo sin ser periodista, técnicamente hablando. Pero también eso nos lleva a el cambio en los tiempos, a la modernidad y a la tecnología. Y no es lo mismo hablar de estos temas en los 60 que hablar del ejercicio y de manifestaciones, del acceso a la información y la libertad de expresión a través de Internet, de los blogs y de muchas otras modalidades en que defensores y defensores de derechos humanos que no son necesariamente periodistas, sí ejercen cotidianamente el derecho a la libertad de expresión. Estamos hablando de investigadores sociales, estamos hablando de organizaciones de la sociedad civil que realizan investigaciones en materia de promoción y protección de los derechos humanos, fundamentalmente los derechos de las minorías. Estamos hablando de defensores y defensoras de derechos humanos que trabajan en zonas de riesgo, de alta vulnerabilidad. Entonces, la idea de la opinión consultiva de la Corte Interamericana es retomada y en el Comité de Derechos Humanos, del cual yo soy parte, hemos analizado la protección del artículo 19 de dos ámbitos, desde la protección, la parte proactiva y la parte reactiva. En la parte reactiva lo hacemos a través de casos contenciosos que se llaman comunicaciones individuales. En ese sentido, el comité se parece mucho al trabajo que hace la Corte Interamericana. Vemos casos concretos. Los casos de libertad de expresión que vemos, sin embargo, en el comité, tienen un matiz bastante diferente de algunos países del este a esta parte del hemisferio. ¿Por qué? Porque la libertad de expresión y el acceso a la información en el sistema interamericano es el sistema más amplio del mundo por el artículo 13, pero yo no me voy a referir a esta parte que le va a tocar a mi colega. Pero el artículo 13, por ejemplo, no permite prácticamente censura previa, salvo casos muy límites. En casos contra Bielorrusia, Rusia, algunos contra Georgia, pero principalmente contra Bielorrusia, existen leyes, decretos a nivel nacional, regional o local que establecen que para que se realice una manifestación pública tienen que pedirse estas condiciones. Una solicitud previa para una reunión multitudinaria. Pero resulta que es una sola persona la que está pidiendo la manifestación, entonces ya de suyo no es una manifestación multitudinaria, pero a esta persona le pueden exigir que presente el contrato de seguridad, porque tiene que garantizar la seguridad de la manifestación pública. Le piden además un contrato de limpieza para garantizar que después del evento pues quede todo limpio. Y si le dan el permiso, que es muy difícil, la manifestación se hace en un estadio cerrado a 60 kilómetros del centro de la ciudad. Ese es un escenario hoy, del siglo XXI. Obviamente el comité ha declarado y ha condenado por violación del artículo 19 en ese caso, en relación con el derecho a la reunión y el derecho a la pública manifestación. En este derecho síntesis como lo ve el comité. Pero el problema que tiene el comité es que el comité no es tan ambicioso como la Corte Interamericana, que ha desarrollado una jurisprudencia sobre la obligación de adecuar el derecho interno a el tratado internacional. El comité es timorato y conservador. El comité no aplica, se niega, se resiste a aplicar la obligación de adecuar la legislación interna al Pacto de Derechos Civiles y Políticos. Por otra parte, el comité tampoco aplica el principio de iura novit curia, que eso es materia todos los días en la Corte Interamericana. Entonces, eso puede generar que en algunos casos no se pueda pues, garantizar de manera tan abierta el derecho a la libertad de expresión. En 3 minutos, el comité, tal vez el aporte más importante, ha sido la opinión o el comentario general número 34, donde, siguiendo la línea de la opinión consultiva 5 de la Corte Interamericana, el comité dice que es tan importante la libertad de expresión que no puede ser inclusive un derecho suspendido. No se puede suspender nunca en situación de emergencias, aun cuando no está en el núcleo duro de los derechos que no se pueden suspender nunca. Entonces, el comité dice, es tan fundamental el inciso 1, el párrafo 1 y 2, que no es suspendible la libertad de expresión. Y cuando los estados los van a restringir por razones de seguridad, el margen de discreción tiene que ser sumamente reducido. En ese comentario general, la obligación positiva del Estado es generar las medidas de protección y de prevención en los casos Mokun contra Camerún, Ñarú contra Camerún y otro caso contra Georgia. En esos casos, el comité ha dicho que no se puede justificar y silenciar a los defensores de la democracia pluripartidista, que no se pueden restringir los principios democráticos y de los derechos humanos, que estos deben ser compatibles con el artículo 19, que los atentados contra las personas son inclusión de formas tales como la detención arbitraria, la tortura, las amenazas de muerte, el asesinato. Este tema de las restricciones, las limitaciones y las violaciones a la libertad de expresión a través de actos de Estado preocupa hoy donde terceras personas, llámese hoy grupos criminales organizados, llámese en conflictos armados internos, etcétera, hace que la obligación positiva del Estado implique responsabilidad objetiva por la falta de investigación y el favorecimiento de la impunidad cuando no se investigan crímenes contra personas que ejercen el derecho al acceso a la información. Estamos hablando de agresiones como secuestros, amenazas, acosos, muerte, ataques, campañas de desprestigio, intimidación, estigmatización, amenazas a familiares, ridiculización, es decir, una serie de actuaciones que pueden realizar el Estado, agentes del Estado, para acallar a la oposición, a la crítica, a la intolerancia a la crítica, etcétera, que es una responsabilidad objetiva del Estado. Y el otro tema que le preocupa al comité es el de las represalias cometidas en contra de periodistas o defensores de derechos humanos que van a los comités de derechos humanos de Naciones Unidas y son amenazados por cooperar, por brindar información, por hacer informes sombra en relación con el acceso a la información que el comité tiene. Pues yo estoy muy rápido, apenas para dejar muestra de la preocupación del comité y estoy a la disposición para ampliar posteriormente. Gracias.
Actually, your comments are so stimulating, I have a question for you. We heard from Michael O'Flaherty at the meeting in Strasbourg 1 year ago that there is more that the UN human rights bodies can do now, and that the role of the Human Rights Committee could be applied rather more directly. It's also suggested that the Human Rights Council and other parts of the UN machinery could be used in a more proactive way. This has even been suggested by in the UN Security Council, bearing in mind that a new resolution was passed only this year, deploring the fact that, or indicating the necessity for states to follow up on cases of attacks, deliberate attacks on journalists in war zones, which, as we know, is extremely rare. What's your comment on that?
Bueno, esto digamos que abre un debate de los riesgos que se puede generar dentro de toda una maquinaria que hay detrás de lo que es el ejercicio del acceso a la información y el mensaje que se le envía exactamente de mordaza a todo lo que hay detrás dentro de estas estructuras. En el comité nosotros estamos entrando a analizar temas muy sensibles cuando analizamos la situación con países y ya no casos concretos, que es donde encaja más esta preocupación de estructuras de restricción, de maquinarias, al acceso a la información, a las organizaciones de la sociedad civil, a la oposición, y algo muy interesante y riesgoso que es el seguimiento a la información confidencial a través de las redes, a través de Internet y los datos privados de las personas. Ese es un tema que hemos analizado en el comité y que se ha tratado de restringir a partir de leyes antiterrorismo, de seguridad, etcétera. Entonces, desde esta perspectiva, el comité acaba de analizar casos de Canadá, casos del Reino Unido, precisamente donde se está cuestionando hasta dónde estas leyes en nombre de la seguridad nacional y de interés público restringen en el acceso a la información y a la libertad de expresión, es decir, hasta dónde están los límites para justificar que la libertad de información y el acceso a la información se puede restringir justificado a través de estas leyes antiterrorismo, leyes de seguridad, etcétera.
Thank you. That does seem to echo the discussion going on now in the Council of Europe forums about the idea of a thoroughgoing review of national laws, because this issue of the use of anti-terrorism laws, the powers of state to surveillance and interception and so on, is now very hot. And Andris and I have both mentioned the climate in Europe of caution or even retreat in this area. So it may be something that could be built on in the future to bring together the obligations of states and the mechanism by which that is tested, it seems to me. So I've kept you waiting very, very long, but Judge Roberto Caldas is coming from Brazil, but he's a vice president of this American court that we are sitting in. We're honored to have you address us. Thank you very much.
Buenas tardes, señoras, señores. Bienvenidos aquí en nombre de mis colegas, el presidente Humberto Sierra Porto aquí presente, los colegas Diego García y Alberto Pérez Pérez, muy bienvenidos, bienvenidas. De hecho, vamos a acotar nuestra exposición. Teníamos la expectativa de hablar el doble del tiempo, pero vamos a tratar de, por ejemplo, retirar una parte importante que quisiera remarcar, que es la libertad de expresión como un derecho protegido en la Convención Americana. Pero ya tuvimos acá por la mañana la expresión del presidente Humberto Sierra Porto y la exposición magistral del juiz y expresidente Diego García Sayán. Bueno, antes de todo, gostaria de observar que estamos aqui em uma mesa de diálogo de instituições universais e regionais, que é um grande gosto tê-los acá, todos vindo de lejos, para discutir este muito importante tema de la violência contra periodistas. Miremos o nome desta conferência internacional: Fim a la impunidad de crímenes contra periodistas. Quisiéramos nosotros de la Corte Interamericana que el nombre cambiara, que fuera, por ejemplo, no tener a la impunidad, ser fim de crímenes contra periodistas. Esse é o ideal que buscamos. E a jurisprudência da Corte, creio que aqui, hasta este momento, não se falou tanto. Nosotros tenemos sempre, em las sentencias, cuidado de buscar ir alá, muchas veces, del común de los tribunales y trabajar con la necesidad de prevención. La obligación de los estados de prevenir que los crímenes ocurran es para nosotros extremamente, sumamente importante. Es decir, quando juzgamos e tenemos juzgados sobre impunidade, particularmente sobre impunidade de crímenes contra periodistas, temos poucos casos, es decir, podemos, se a Corte recebe mais casos, podemos fazer mais. Então, este aporte é importante e já é uma parte da resposta a las obrigações positivas do Estado, que é prevenir a ocorrência de crímenes. Claro que a liberdade de expressão é tema sumamente importante, pero passaremos pouco lá para estabelecer este diálogo tão querido por la Unesco e por nós que estamos juntos organizando o temário, assim como a senhora Pilar de la Unesco, Edson Lança, nosso relator para liberdade de imprensa de la comissão, e que temos falado também com o jurista Baltasar Gasson, que aqui presente é honor para nós. Bueno, o assassinato a periodistas e a las personas dedicadas a la comunicação, ou seja, em geral, desde a opinião consultiva 5, se estabelece aí que todas as pessoas dedicadas à la comunicação, que sejam defensores de direitos humanos, partícipes ou liderazgos de las comunidades, todos têm direito à la liberdade de expressão, seja em sua expressão individual, seja em la expressão coletiva, também como direito de las comunidades a receberem e de la sociedade como todo a receber informação calificada e plural. É decir, temos abanico de opções de direitos a desarrollar. E liberdade de expressão é, sem dúvida, de los temas mais importantes desta quadra de la história que temos adelante. Já temos importantes aportes, também como Diego. Sou optimista a mirar o trabalho que esta Corte ha dedicado ao largo de sua história e atualmente. Bueno, a Corte ha señalado especificamente que o exercício periodístico solo puede efectuar-se livremente quando as pessoas que lo realizam não são vítimas de ameaças nem agressões físicas, psíquicas ou morais, ou outros actos de hostigamento. Qualquer afronta não só vulnera especialmente o direito à liberdade de pensamento e expressão de aquela pessoa que diretamente recebe o ataque, sino que afeta a dimensão coletiva deste direito. Tal como tivemos oportunidade de apreciar ao largo desta manhã, através de casos, estatísticas e números apresentados por outros panelistas, são muito graves as ocorrências. Em nossa região, muito especialmente, cifras da Comissão Interamericana, só em 2014, al menos 25 periodistas fueron asesinados por motivos que podrían estar relacionados con el ejercicio de la libertad de expresión. Estas cifras en nuestra región resulta de intolerancia sumamente preocupante, teniendo en cuenta que en 2014 en todo el mundo fueron 61 personas. Es decir, tenemos una grave situación que la Corte ciertamente puede examinar más casos. En estes 3 últimos minutos, gostaria de rapidamente, entonces, ir directamente a las obligaciones positivas. En el marco de estas obligaciones que los Estados, en cuanto a la protección de los derechos a la vida, integridad y libertad de expresión de los periodistas, existen 3 tipos. 1, la obligación de prevenir, que fue la primera que hablé, la obligación de proteger y la tercera, la obligación de investigar, juzgar y, de ser el caso, sancionar a los responsables. Bueno, todo el seminario está dedicado a, más específicamente, este último, de evitar la impunidad. Cuando la impunidad es evitada, se evita el crimen. Hay un jurista, Beccaria, de Italia, un clásico del derecho penal, que dice que no es el tamaño de la pena que evita el crimen, pero la certeza de la punición. Entonces, es muy importante combatir todos y cada uno de los casos de agresión, de violencia, cualquier que sea, en contra periodistas, porque esos y los comunicadores en general son siempre defensores de la sociedad, defensores de los derechos humanos, y nosotros no podemos admitir este mundo de agresión, esta región donde se atenta tanto en contra los periodistas. A todas y todos, muchas gracias y seguimos a disposición. Muchas gracias.
Thank you very much. I'm sorry to hurry the speakers along, but we have now a good 45 minutes to have the open debate that was promised. So I did raise a few points at the beginning about how what is the real usefulness of case law. How can the obstruction by some states or other actors be addressed in order to make case law and the provisions of the conventions and the international norms truly effective? And perhaps towards the end we might consider in what way this dialogue might be continued fruitfully in future among the jurists present, since we have a unique collection, I think, of international jurists here present in this room. But I hope we have some microphones which can be used for, we do, so at the back microphones, please would you raise your hand so that I can see, and I'll call the gentleman near the front, if I'm right. Yes, no. It was a at the back, in the back row, we have a hand raised. Thank you, the lady. Would you give your? Would you identify? I think I know.
Toby Mendel, Center for Law and Democracy. I just want to pick up on something that you said. That states were voluntarily, accepting to review their legislation and so on and so forth. And I'd like to point out that under international human rights law, there is nothing voluntary about that. States sign treaties. human rights treaties, and those treaties oblige them to ensure respect to their citizens and people within their jurisdiction of the rights that are guaranteed there, and if necessary, that requires them legally to amend their laws so they're no longer abusing the rights of their citizens. We have to be very careful here not to confuse the obligations that states have with the ways that we enforce those obligations through the international courts and things which pinpoint case law and individuals who complain and so on and so forth. But the obligation to bring your legislation into line with the Human Rights Treaty exists from the moment you become a party to that treaty. It's no more voluntary than obeying the speed limit, although, of course, as my taxi drive to the hotel last night demonstrated to me, not everyone always obeys the speed limit, but it's still a legal obligation.
I'd just like to briefly respond to that. I think what is perhaps unique about this proposal is that there would be the same starting point for all the member states by common agreement, that it would be a comprehensive, thorough, overgoing review, that it is proposed in the draft text, that this is not yet approved by the ministers themselves, that governments would be called on to create the conditions, favourable conditions for such a comprehensive review, that it would actually be conducted by independent bodies. A lot of discussion about which bodies, perhaps the commissioners for human rights, the ombudsman, or other independent organizations, but drawing on the knowledge of civil society and stakeholders of all kinds. Eventually, of course, it would have to be followed up by being presented to a government, and then the legislature would have to enact laws. So the idea that states which regard themselves as beyond reproach, or at least have not accepted that there is an urgent need, that they would be encouraged to undertake this rather broad brush thing, I think is something rather novel, and we will have to see how it responds. But it is perhaps one of the elements of the idea of a more proactive stance, which, as we've said, we've heard from some of the UN bodies. We've heard this morning a great deal of evidence of how the case law in the Inter-American Court, despite its limitations of resources and the number of cases heard, is setting new precedents. And what I think the civil society and many people involved with human rights would like to see is the joining up of these elements of progress in a way which is which can be drawn on, which can actually be useful to people who are suffering from these violations in all judicial circumstances. Perhaps I could call on you again, Judge Ramadani, after having heard the other speakers today. How would you frame a future for the African Court, which to you would satisfy the real need of the Human and People's Court for providing the kind of protections which are necessary in the circumstances of Africa? What are the most urgent needs? Is there something in the history of the development of the European Court of Human Rights and its framework, or the Inter-American Court in terms of the participation of the states, individual petition, the mandate and authority of the court, which you would like to be able to emulate?
There are quite many. We came here, I think, about 3 years ago to visit the Inter-American Court. I was one of them. I think we were 4 judges. And we learned quite a lot. And in fact, the Inter-American judges led by the president himself will be coming towards the end of this year to Arusha. And we're going to have thorough discussion on that. And I think there are so many things to be emulated from that. We went to Strasbourg, and we talked to the judges there, and also we have learned a lot. One of the things which I think will assist us in the African Court is one, well, this is not so much of the Inter-American Court, because they are also ad hoc like ourselves. They just come in, they're not permanent here. But I think the Strasbourg, the European Court, they are there. And it is all the European countries who participate. So that is one thing, to broaden the number of judges who will be residential there, because this system of just coming in for 2 weeks and going back is not really very good. One. Two, finances. Our court is very much under-financed by the African Union. And we have that, that problem of that. Number three, personnel. The court has got just 7 lawyers. Now, 7 lawyers to cover the whole of Africa. And even to service 11 judges is a joke. But also, the other thing now, I've even forgotten what number. But the other thing is enforcement of judgments. So far, our court is young, and we have not had jurisprudence to ensure the enforcement of judgments. Because as far as I'm concerned, it's useless for a court, even if it's very, very independent, to give a judgment, but that judgment is not enforced. There is no independence there unless the judgment can be enforced. And this is what we look for. These 2 cases which I have just cited about Burkina Faso, I think we have given them 6 months, and the 6 months are yet to be over. So we are waiting to see whether Burkina Faso will implement them or not. But so far we have had other problems with other cases, not on journalists, with respect to Libya. And we have kept on reporting to the assembly of the heads of states assembly in June and in January and June about the non-execution of our decision by Libya. So the execution of judgments, I think this is what we want to learn from these other older courts. But also you talked about case law. In our 2 cases, unfortunately I don't have the cases, the reports of the cases here, but we relied heavily on what was decided by the European Court and also by the American Court in making our decisions. Because these were novel, as I said, just 9 years, these were novel cases, and we relied heavily on that. And we shall rely even more heavily. Maybe, I don't know, I've covered what you wanted.
Yeah, I hope some people will pick up on some of these points, because I think the particular nature of this conversation is that it is international, global, interregional, and we have here so many different authorities and mandates. Andres Melikals.
Thank you, William. Just to come back on what Judge Ramadani said, that the African court relied heavily on the Inter-American Court and on the European Court. And here we have a wonderful irony in that one member state in the Council of Europe who says that the role of the European Court for Human Rights, while substantial, should also not be misinterpreted. This member state reaffirms its position that the decisions of the court are only legally binding vis-à-vis the parties of a specific case and do not automatically create universal standards. So the question here is, at which stage can you take the rulings of another court and use it in evidence, and when you can't? This is fascinating to me.
Well, we have a room full of judges, so you'd be welcome to respond to that. It does seem to me that it's clear, though, in the European context and indeed the inter-American context, that the rulings are indeed binding. And in fact, I think in the European case, there are many complaints that the general measures which should follow individual rulings are not followed up, and so there is a repetition of offences. But on the other hand, fines which are imposed have, as far as I know, always been been paid in full, and there is a great deal of political pressure. It is very largely a matter, I think, of the political pressure on states as to whether, in the end, the reforms are done. And of course, the European Court has undertaken substantial reforms through the Interlaken process, ending with the Brighton Declaration, which were aimed at cutting the enormous backlog of more than 100,000 cases, much more than 5 years for cases to be heard. These reforms, I think, have improved the image of the court in the public mind, even though in my own country, as I mentioned, the government is attempting to distance itself from the authority of the Strasbourg Court, and is even saying that its rulings should be advisory and not binding. But that is not yet in law. It is a position taken by a one-party government, and it remains to be discussed. And there is very strong voices on the other side suggesting that this would be a very serious, in fact catastrophic, damage to the UK's reputation as an upholder of international law. So the debate continues. From the floor, yes, sir.
Bueno, con las disculpas del caso, voy a patear desde el otro lado y me voy a explicar. Estamos hablando mucho aquí de cómo hacer que las sentencias de las cortes internacionales tengan vigencia en los Estados miembros, e incluso de cómo cooperar para que ello ocurra en uno y otro continente. Yo quiero poner un punto de atención sobre algo que creo todos debemos saber que está ocurriendo en nuestro propio continente con el tema del sistema interamericano. A mí personalmente me ha tocado escuchar en varias reuniones de jueces de varios países, ministros de corte de varios países, una tendencia que no me parece, yo no estoy de acuerdo con ella, pero sí hay una tendencia visible de jueces, de magistrados, de ministros de corte de considerar, o por lo menos empezar a plantear el debate de si las sentencias de las cortes, de la Corte Interamericana, no son una especie de, exacerbación de contra la autonomía, contra la soberanía jurídica de los propios estados. Sí, podríamos hablar de todas las cosas que nos gustan hoy. Esto es algo que puede aparecer en el horizonte como un elemento contraproducente de lo que estamos hablando. Eso yo lo he escuchado, he participado, ha habido debates, hace un año en Buenos Aires, en una reunión participamos, doctor Roberto Calda, usted se recordará que ha habido de diversos países posturas al respecto. Particularmente en la Corte Paraguaya estamos, creo por lo menos todavía, en la tesitura de si acoger la jurisprudencia interamericana. De hecho, en un caso muy puntual y muy paradigmático en nuestro país, hemos acogido la jurisprudencia del caso Clos Reyes sobre acceso a la información pública, y eso ha sido toda una revolución interna en el Paraguay, porque ese acogimiento de la jurisprudencia interamericana promovió internamente, fíjense usted, la elaboración de un proyecto de una ley sobre acceso a la información pública. O sea, pero eso que estoy señalando, yo lo estoy viendo y lo estoy notando. Participo en las reuniones de la Cumbre Iberoamericana Judicial. No digo que esta sea una posición de la Cumbre Iberoamericana, pero escucho a jueces que piensan, a ver si no hay que plantearse de si esto no es un atentado contra la soberanía, entre comillas, la soberanía jurídica, jurisdiccional de los Estados miembros. Solamente quiero dejar sentado eso como un elemento para el debate, para la reflexión, y sobre todo para que los escenarios futuros no nos tomen de sorpresa.
Would you like to respond? Yes, please.
Muy Muchas gracias por su inquietud. Esto nos involucra a todos y el debate para nada es nuevo. Debería estar superado desde mi punto de vista. Pero no es nuevo y se está retomando porque hay resistencias. Y hay muchas resistencias porque los estados ahora se están enterando fuertemente de la importancia y la dimensión que tienen la jurisprudencia internacional. Yo creo que en los 60s los estados no tenían idea de lo que estaban firmando y ratificando, ni con la Convención Americana, ni nada. Entonces ahora sí se enteran y entonces sacan la bandera de la soberanía. Pero la bandera de la soberanía se cae sola porque el derecho internacional existe per se como un valor fundamental de voluntariedad, como decían aquí, pero es vinculante, artículo 26 y artículo 27 de la Convención de Viena sobre el Derecho de los Tratados. Ese es el pilar del derecho internacional y el de los derechos humanos. Es decir, el principio de buena fe, el Estado no ratifica tratados con pistola en mano, lo ratificó soberanamente, pero además al ratificar le ponen número de ley al tratado. El tratado no está en el espacio. Entonces, el debate sobre monismo y dualismo, muy bien para las clases de derecho internacional, pero en la práctica, el sentido práctico que tiene hoy es el 26, el Pacta Sunt Servanda, y el 27. A los que creen en la soberanía, el 27 dice no se puede invocar el derecho interno para incumplir una obligación internacional. No se puede invocar la Constitución no juega. La Constitución no es un instrumento de carácter internacional, está en otra liga. Entonces, podemos hablar, ríos, sobre este tema. Este tema sale porque particularmente la Corte Interamericana ha tomado unas líneas jurisprudenciales espectaculares a nivel de reparación. Entonces, ahora dicen que la Corte Interamericana es activista y hablan de jueces activistas. Y qué bueno, porque no es activista en sentido peyorista, es que al Estado, al no hacer la tarea de realizar los derechos humanos a través de políticas públicas, le toca a los poderes judiciales y a los internacionales tener que enmendar la plana de lo que no hace el Estado. Y eso es a lo que llaman activismo. Entonces, las sentencias de la Corte Interamericana hacen llamados de efecto erga omnes a un caso concreto. Entonces dice, en este caso hay que crear una política pública, hay que capacitar, hay que ser proactivos, etcétera. Eso le duele a los estados. Entonces quieren invocar la soberanía y quieren invocar el margen de la discrecionalidad. Si los estados pueden hacer todo lo que quieran hacer, los tratados internacionales no, pues es simplemente unos referentes mínimos que también tienen que estar en la Constitución. No es nada nuevo. Pero esta resistencia es universal. La vi en España con el Comité de Derechos Humanos, terrible la posición de España sobre si son vinculantes las comunicaciones del comité, dicen que no, dicen que tiene que haber un reglamento cuando la Constitución dice una cosa, Canadá igual, invocando monismo, es decir, dualismo, monismo, podemos seguir debatiendo sobre esto, pero desde el punto de vista del derecho internacional, artículo 26 y 27 son vinculantes, no solo las sentencias de la Corte Europea, Corte Interamericana, sino también las resoluciones de organismos internacionales que devienen de tratados internacionales como la Carta de la OEA o la Carta de la ONU. Gracias.
Could I just clarify? You say that the communications are binding. I mean, in what sense are they binding? And also, what about the content of General Comment 34? That is an interpretation of the Covenant on Civil and Political Rights. In what sense, if any, is it binding?
El presidente del comité hizo un comentario, del Comité de Derechos Humanos, Fabián Salvino, hizo un comentario, dijo que las comunicaciones individuales eran vinculantes y dijo que el comité era el último intérprete, el principal intérprete del Pacto de Derechos Civiles y Políticos. Y hay un blog de canadiense donde cuestiona fuertemente esas palabras del presidente, dice que no, que el comité no tiene facultad de ser el último intérprete, que el intérprete son los estados. Bueno, ese es un debate interesante, pero nos lleva un poco a lo mismo, es decir, ¿qué sentido tiene crear un comité que aplica el Pacto de Derechos Civiles y Políticos, y para aplicarlo lo tiene que interpretar, y su resolución de una comunicación, aunque no es una sentencia en términos, porque no somos una corte, somos cuasi judicial, es vinculante en el sentido de que deriva de un mandato de un tratado que creó al comité y que creó un procedimiento de quejas individuales que se llaman comunicaciones individuales. Y desde esa perspectiva, por supuesto, que las recomendaciones que hace el comité son para cumplirlas, no son para no cumplirlas. Es que el principio no funciona hacia la voluntariedad de los estados. Funciona que si los estados ratificaron el Pacto de Derechos Civiles y Políticos, suscriben el mecanismo de aceptar las comunicaciones individuales, es para cumplir con esas recomendaciones desde las otras normas del derecho internacional, el Pacta Sunt Servanda, artículo 26, artículo 27. Ahora, la observación general, el comentario general 34 sobre la libertad de expresión, viene siendo un poco como las opiniones consultivas de la Corte Interamericana de Derechos Humanos, es decir, es una opinión que se hace a partir de preguntas. En el caso de los comentarios generales es un análisis del derecho, de un artículo específico, pero además lo que hace el comité no es nada nuevo, sino lo que hace es sistematizar la jurisprudencia del comité. El comité no es que se abalanza a ser creativo en abstracto. Para mi gusto, los comentarios del comité son muy restringidos, a solo no dice más de lo que no haya dicho ya en los comités, en las comunicaciones. Entonces, son vinculantes en el tanto y en el cuanto lo ha dicho en casos individuales, en relación con países, y viene siendo una suerte de doctrina, viene siendo una serie de principios y de otras fuentes.
Roberto Caldas, please.
Muito obrigado. Es una cuestión muy importante que trae acá nuestro magistrado paraguayo, Dr. Costa, porque essa é uma questão derivada de largo de tempo que nossa região, por las dictaduras que tuvimos, nos quedamos alejados del direito internacional e também de los derechos humanos dentro de las universidades. Nosotros não teníamos las disciplinas propias a manejar estes importantes derechos fundamentales. Entonces, esa es una cuestión que sí, comprendo muy bien la manifestación del magistrado Costa, porque tenemos participado de importantes eventos de diálogo, que llamamos los encuentros de de presidentes y magistrados de tribunales y salas constitucionales de Latinoamérica. Estes encuentros anuales, y este año, vean que significativo, el encuentro se realizó acá en la Corte Interamericana de Derechos Humanos, para se ver cómo los tribunales nacionales tienen evolucionado, como la cuestión de los derechos humanos y especialmente de la Convención Americana sobre Derechos Humanos está impactando también la jurisprudencia nacional. Entonces, es decir, ¿tenemos problemas nacionales? Tenemos. En Brasil especialmente también. Cuando decidimos en la Corte Interamericana el caso Gomes Lund o guerrilla do Araguaia, el presidente del Supremo Tribunal de entonces, mi amigo César Peluso, fue a la televisión y dice, bueno, nosotros en la verdad no tenemos obligación de seguir, porque tenemos la soberanía. Entonces, pero esto hace menos de 6 años. ¿Y cuánto caminamos hasta aquí? y el Supremo tiene decidido importantes cuestiones siguiendo la jurisprudencia de la Corte Interamericana. Hace un mes, Brasil empieza a hacer la audiencia de custodia de todo detenido, es decir, en 24 horas que uno es detenido, hay que ser llevado a un juez, siguiendo la jurisprudencia de la Corte Interamericana y la Convención Americana. Entonces, veo también con optimismo porque estamos logrando dar efectividad a la jurisprudencia. Sobre el tema de jueces activistas, yo prefiero otra denominación, de jueces que miran el ser humano, la persona humana. Somos jueces humanistas. Gracias.
Thank you. I'd like just to add a point on that, because the discussions that are being conducted now in the Council of Europe focus on the concept that these commitments, the obligations under the Convention and are not to be theoretical or passive, but they must be practical and effective. And that, I think, is the basis on which these ideas are being brought forward in the European context, in a difficult political environment, to accept that the role of the member states as the intergovernmental part of the Council of Europe, but also of the judiciary and the agents of the state, of all agencies of the state, are bound by these and must be seen to be bound by them. So actually I wanted to ask you another point about Brazil. You mentioned the difficulties in the Brazilian system, and I was very struck when the World Press Freedom Day was held here just a couple of years ago, that the then Supreme Court President Barbosa spoke very outspokenly about the defects, and indeed he even suggested criminality in some parts of the judiciary, which he linked, I think I report this accurately, directly to the problem of impunity in cases of killing of journalists in some of the regions. This morning, I note also we heard, I think, in discussion on Argentina, and other countries, that the infection of the political and the judicial system is at the core of the intransigence, the difficulty of addressing impunity. And the same would surely be true in the cases which the CPJ report identifies as the worst offenders of all, in countries where the rule of law has broken down. Would you have any comments on the ways in which perhaps the judicial community, the legal community themselves, might adopt a more proactive attitude towards cleansing, towards standards within the profession, and what positive impact that might have on the fight against impunity?
Excelente cuestión que podríamos hablar aquí por una hora más o menos. Bueno, el ministro que fue presidente, Joaquim Barbosa, teve una excelente participación en casos en contra corrupción, por ejemplo, buscando enfrentar una impunidad que también, no solamente en los crímenes en contra periodistas, pero en general en contra la corrupción. Y en diversas áreas también. El sistema judicial brasileño no es tan diferente del sistema de Latinoamérica. Tenemos muchos puntos a trabajar y tenemos que hacerlo. Evitar, en primer lugar, la demora del proceso. Los procesos han de ser sencillos y rápidos a seguir la jurisprudencia de la Corte Interamericana, pero ese también é um problema grave que vemos acá. 80% de los casos que chegam à corte, 80%, a corte determina, encontra violação a los artículos 8 e o 25, es decir, por não se dar a devida entrega de prestação jurisdicional efectiva ou em seu tempo. Então, também o problema de impunidade há que ver com este sistema que é muito complexo. Nós temos que cambiar o sistema para processo muito mais rápido. Digo que os processos em Latinoamérica são inspirados em antigo processo civil italiano, que era excelente para siglo atrás. Nós temos que empurrar reformas do judiciário porque temos que vencer os processos em tempo razonável.
Sí, sobre este mismo punto y este planteamiento que están haciendo, voy a responder con anécdotas. Yo creo que el problema que se ha traído al debate sobre la obligatoriedad y si son vinculantes y toda esta temática y la voluntad y actitud tiene que ver con escuelas de formación jurídica en el derecho internacional de los derechos humanos. Y yo sí me encontré sorprendido cuando entré al Comité de Derechos Humanos porque mi formación viene del sistema interamericano y en un caso donde la víctima no invocó un derecho, era evidente la violación, pero no lo invocó, yo dije, ira novit curia, es decir, vinculemos este otro derecho que no está indicado. Y el presidente, nuestro querido amigo común Nayer, me dice muy respetuoso, quiero explicarle al nuevo miembro que el comité no aplica el ira novit curia. Bueno, el ira novit curia está reconocido hace más de casi 100 años por la Corte Permanente de Justicia. Entonces, hay una visión eurocéntrica, con respeto lo digo, sobre unas tendencias que hay en este momento hacia la protección de los derechos humanos y los alcances del derecho internacional de los derechos humanos, y voy a hablar de una escuela americana que ha avanzado tremendamente en el tema de la protección internacional de los derechos humanos. Puedo hablar hasta de un derecho procesal interamericano, si se quiere, de medidas cautelares, de la progresividad de los derechos humanos, etcétera, donde va a años luz, el sistema interamericano va a años luz a nivel de la protección y esta progresividad. Veo una ley de péndulo hacia acá, veo retroceso de muchos países europeos y mucha resistencia a través de estos temas, pero voy a dar dos ejemplos positivos. En el caso Bulacio contra Argentina, la Corte Suprema no estaba de acuerdo en una parte de la Corte sobre la imprescriptibilidad en la investigación de un delito. Y dijo, no estoy de acuerdo con la posición de la Corte porque no es un delito de lesa humanidad, pero vamos a cumplir, y cumple. Lo mismo México, en relación con sentencias de la Corte Interamericana, y dice en una contradicción de tesis que los jueces, pero también lo dice la Corte y México lo acepta, que los lineamientos de las sentencias de la Corte Interamericana y la jurisprudencia, aunque no sean contra México, deben ser aplicados por los jueces, y eso no es poca cosa. Y la misma Corte, después de México, dice que el debido proceso, por ejemplo, tiene que representarse en todos los procedimientos administrativos. Y la jurisprudencia de la Corte también, no es solo para los jueces, es para todos los funcionarios administrativos. Y eso me parece supremamente importante porque en Latinoamérica hemos aprendido a utilizar la doctrina del bloque de constitucionalidad, que no es nueva, tiene más de 200 años, pero gracias a Colombia, hablar en Colombia de bloque de constitucionalidad es como hablar de esto, en Colombia es materia vista, en Colombia no es un debate, creo que en Argentina tampoco, en Costa Rica yo creía que no lo era, en Costa Rica están pasando cosas que me preocupan a nivel de Corte de Constitucionalidad, pero hay una tendencia y un avance de las Cortes Constitucionales muy sorprendente y positivo en Latinoamérica.
Judge Ramadani, there's a lot of interest, I think, in what is in your mind during this conversation and the particular points we've just heard.
Thank you. Well, I think under international law, one thing is very clear. There is this principle of pacta sunt servanda, where it means that parties to a treaty are bound by that treaty. So there is no question, I think, about that. But when it comes to decisions, for instance, the decisions of the Inter-American Court or the decision of the European Court do not bind the African Court. But what we do, in the common law system, we say they are persuasive authorities. And we need to have a very strong reason why we should part from those decisions if they are doing their decisions on, as they say in the common law, on all fours, that they deal with the same matter in the same circumstances. So that is what we are doing. But also, for us, we have learned quite a lot. For instance, in this question of Zongo, when it came to reparations, and even the other one, when it came to reparations, some of us from the common law system, you make reparations or you order compensation only to dependents, to spouse and the children who are depending on the deceased, or even the parents if they are depending on the deceased. But we found that in the decisions, I think, of the Inter-American and even in the European Court, that they give even to people who are not really dependents. And that is what we took it upon us, and we have given that reparations, even not to dependents. But for some of us, from our training, it is only dependents. But we are copying that. And then I think, from what you have said, William, about the Council of Europe and the review of laws, for instance, it's interesting for us. We are waiting to see what the states, Burkina Faso, will do. Because we have, in many countries, and especially those under common law system, we have criminal defamation, whereby defamation, if it is criminalized and the defamer is prosecuted and found guilty, can be jailed. Even in my own country, Tanzania, I come from Tanzania. Even in my own country, Tanzania, we have criminal defamation. And this court of the African court decided that, yes, we can have criminal defamation, but not punishable by imprisonment. So we don't know how many countries within Africa, including Tanzania, my country, will change its law accordingly. Thank you.
We have very little time left. I wondered whether, since we have the honor of the presence of the President of the Inter-American Court here, before we finish, if you have any comments to add to the rich discussion that's been had, that would be welcome. But to give you time to collect your thoughts in case that's the case, perhaps I could invite, if there's no questions from the floor that have, by way of urgent questions, yes, we have one very urgent, please.
Sí, voy a hacer un poco breve la pregunta, pero está más enfocada en el punto que los periodistas no solo son asesinados, es la forma más grave de crimen, pero no es la única. Entonces quisiera saber, como desde la perspectiva de los tribunales internacionales, cómo podemos mejorar la situación de personas que son desaparecidas, que son arbitrariamente detenidas, que mujeres que son atacadas sexualmente, que forman parte de estos otros crímenes que los periodistas son objeto, pero que no llegan a este punto de ser asesinados. ¿Cómo puede ser esa respuesta internacional? Gracias.
Please.
Disculpen por abusar de la palabra, pero a mí me parece que el informe de la Relatora Especial de Libertad de Expresión de la Comisión Interamericana es impecable. Y ahí, en ese informe, se habla de todas las obligaciones positivas del Estado, de protección, de investigar, etcétera, y ahí está la pista de lo que tienen que hacer los Estados en ese sentido. A mí me preocupa que se enfoque el tema de la protección de los periodistas amenazados o que sufren todas las secuelas que usted ha dicho, que puede ser torturados, desaparecidos, etcétera, o amenazados de que ello ocurra, o sus familiares, y que se piense que el único mecanismo de prevención y protección es la investigación, la condena. Por supuesto que sí, pero eso no va a alcanzar para evitar, porque no se está atendiendo el problema fundamental de la violencia estructural contra los periodistas, porque no es contra los periodistas, es contra la función y el derecho amplio del acceso a la información que lo ven las dictaduras y los grupos de criminalidad organizada como una amenaza. Ese es el problema. La bronca, por decirlo algo, no es con el periodista en sí mismo, es con el ejercicio del derecho y de la libertad. Entonces, por ejemplo, en Colombia tienen una política, están diseñando, trabajando en una política de protección a defensores y defensoras de derechos humanos, y tienen tal cantidad de medidas de protección y cautelares y provisionales del sistema interamericano, más de 20.000 medidas de protección policiales, etcétera, hay en Colombia, pero no se estaba trabajando tanto en el análisis de las causas para evitar que siga ocurriendo la amenaza. Aquí está el señor Baltasar Garzón, que entiendo que ha ayudado bastante en la parte de mejorar el análisis de los casos. Es decir, ¿qué hay detrás de un caso que se investiga y se va a investigar y condenar? No se cierra con la sentencia de ese caso. Es decir, ¿qué hay detrás? ¿Por qué en la zona, en el departamento, etcétera? ¿Qué es lo que está haciendo? ¿Por qué no se atiende a ese problema de riesgo? Entonces, es un trabajo muy complicado, pero ahí están las pistas para hacer una visión más integral de la prevención.
Mr. President, would you like to bestow a few words on us before we start to close?
Sí, yo quisiera agradecerle al señor moderador la oportunidad de intervenir, aunque nuestro representante es nuestro vicepresidente, el juez Roberto Caldas. Sí quisiera hacer dos comentarios sobre este interesante panel que ha trabajado el tema de cómo evitar la impunidad y cómo las relaciones entre los distintos órganos internacionales, por una parte, y entre los órganos internacionales y las jurisdicciones internas pueden contribuir a trabajar en contra de los procesos de impunidad contra periodistas. La Corte Interamericana, para hacer cada sentencia o una opinión consultiva, tiene un protocolo interno de investigación, en donde cada tema que nosotros tenemos que estudiar debe revisarse, que ha hecho la jurisprudencia de la Corte Europea, que ha hecho la jurisprudencia africana, que han dicho los órganos internacionales, tanto los del sistema de Naciones Unidas como las del sistema interamericano, los relatores, todas las actividades que hayan sobre el particular. Y tenemos un listado de órganos que tenemos que revisar cada vez que se va a elaborar una sentencia, de manera tal que hoy en día lo que se haga en cualquiera de estos órganos de carácter internacional es estudiado por la Corte como un insumo para determinar si es aplicable o no a este caso, en el entendido en que nosotros aplicamos la convención, pero todos estos insumos nos permiten hacer una interpretación mucho más ilustrada por parte del trabajo que nosotros hacemos. Entonces, eso a nivel, digamos, de órganos internacionales se hace. A nivel de tribunales nacionales de la región, nosotros hacemos también un barrido de toda la jurisprudencia de todos nuestros tribunales de Cortes Supremas y tribunales constitucionales, lo que se está reflejando en las citas constantes de lo que están haciendo los tribunales que aceptan la competencia de la Corte sobre los temas en particular. Y nosotros con los tribunales también tenemos la relación de que somos citados permanentemente, y todo esto es lo que se ha denominado el diálogo jurisprudencial, que hoy en día es una realidad. Este año la Corte Interamericana ha realizado 3 eventos con todos los presidentes y magistrados de Cortes Supremas y de tribunales constitucionales de la región. Realizamos uno en Barcelona, realizamos uno en Madrid, realizamos uno en Costa Rica, por colocar un ejemplo de que hoy en día, sin duda alguna, esa discusión cada vez se va diluyendo por la práctica. En materia de, y este es un aspecto, y el segundo punto que queríamos compartir con ustedes, es lo relativo a que, de acuerdo a la convención, todos los estados deben desarrollar políticas, adecuaciones normativas y políticas públicas para hacer efectivos los derechos y particularmente en este caso la libertad de expresión. Aquí lo interesante es que la Corte Interamericana, cuando hace una condena en un caso concreto, puede estudiar, puede utilizar los estudios que realizan los distintos órganos internacionales en donde hacen propuestas de políticas públicas para mejorar los derechos en un caso concreto. Y quizá donde estamos encontrando un aspecto que hay que desarrollar es que los órganos, tanto a nivel internacional, particularmente del sistema de Naciones Unidas y del sistema interamericano, no están desarrollando, o mejor dicho, se están quedando un poco a la saga y se están quedando en la formulación de los problemas y no están participando en las propuestas de soluciones de políticas públicas. Tanto es así que la Corte Interamericana en más de una ocasión se ve un poco restringida en la medida en que nosotros tenemos que utilizar los insumos para luego, eventualmente, en la medida en que sea pertinente, poder establecer ese tipo de órdenes a los estados en un caso concreto. Pero que sin duda alguna creo que esa comunicación constante y los aportes que realicen grupos interdisciplinarios de estudio para mejorar las condiciones en materia de derechos son de lo más importante. El ejemplo que señalaban acá, los análisis de contexto, los análisis para tratar de acudir a la lucha contra los delitos que se cometen contra los periodistas, no solamente desde una perspectiva individual, sino cuando son producto de organizaciones criminales mucho más extensas, necesitan necesariamente de una visión que va más allá del caso concreto. Muchas gracias.
I think that deserves a round of applause. Thank you very much for that very valuable and I think encouraging concluding thought, President Porto, especially the idea that somehow the jurisprudence is indeed a seamless, joined-up phenomenon which should be drawn on and which states should be more aware of and which it is the role of all who care about the rule of law to ensure, I think, is enforced. I think the focus of our discussion has been very much on moving away from the need to prosecute to the need to prevent and to protect in the first hand. I recall the comment of an African journalist who was told that there was going to be a big focus on impunity, and he says, what are you suggesting, that I'm not going to last because you're already thinking about what you'll do after I've gone? So it's much better to prevent and to protect than to have to prosecute. I would like just to quote the words, speaking about judicial positivism, shall we call it, the words of Professor Karen Alter, American international law professor, who I think has written an extremely interesting book called The New Terrain of International Law, which presents a very encouraging picture of the growth of the principles of supranational, international courts in almost all areas of human affairs, from the law of the sea to world trade to, of course, the human rights regional courts, and indeed some which in some parts of the world are in the course of earlier stage of development. And I think that is the thought that I would like to conclude on here, that this discussion has been helpful in giving us some pointers about the gaps, the shortcomings, the urgent needs, and also perhaps what can be done by all of us together through this process and others to build this solid foundation and solid structure of protections which we all depend on. I repeat, it is, I think, a great shame, a great pity that we've not had the benefit of a senior representative from the European Court of Human Rights, and I hope that will not happen again, because the European Court prides itself on being the most developed system in the world. We've heard things today from this discussion which suggest that perhaps it has strong challenge from this part of the world, which is very encouraging to hear. And my final thought is that, we are coming up to November the 2nd, International Day to End Impunity. Thank you very much to all who've made this opportunity for debate. Thank you to UNESCO for if I may say so, for drawing up a very clear and logical basis on which to draw the attention of states, all the UN member states, to this urgent need, not only on behalf of those who report or in the media, but on behalf of whole societies. So it just remains to thank you, all the members of the panel, and Judge Ramadani for coming all the way and giving us an extremely unique and important insight. Andres Melakals, Costas, and Mr. Rodriguez Resha. Thank you very much, and I hope you'll enjoy some tea after this long session.
Agradecemos a los panelistas